All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the statewide training initiative with Florida Legal Services. We're excited to have you join us here today for junk fees and bogus charges, consumer claims arising out of Florida landlord-tenant disputes. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. If you're registered, you're going to receive a copy of this recorded in an email from Zoom within 24 hours. That email will include a copy, a link to a folders material, which will include the slides and some other cases and materials that have been shared by the speakers. I'm going to drop the link to the materials into the chat as soon as I'm done wrapping up this part, so you can have access to the materials immediately. The training was approved by the Florida Bar for CLE credit. It was approved for 1.5 general CLE, 1.5 real estate certification, and 1.5 civil trial certification credits. I'll share the code for the CLE towards the end of the webinar. It will also be included in the email that goes out from Zoom, and I'll drop it into the chat towards the end just in case as well. If you have any questions, which I know I probably have a few already, during the presentation, feel free to use either the chat, the Q&A. We will try to address the questions as they come in if they are related to the topic, but we have saved some time towards the end as well to be able to address any questions that were not answered. Closed captions are enabled for anybody who needs them, so if you're having any issues with accessibility, let me know. This training is being co-hosted by the Public Interest Law section and with NACA. As to the Public Interest Law section or PILs, if you're not familiar, I'm going to drop the link for the Public Interest Law section into the chat. It's the current membership fee is $55, and you have access to a lot of these CLEs that we put together. Today, after the webinar, we actually have one of our consumer tenant work group meetings. So this is one of my favorite meetings to actually attend. We have a lot of great people there. So if you're not familiar with that work group, I definitely recommend you take a look at our website, which I'll drop into the chat. And with that said, I want to make sure I will pass it on to my friend and colleague Amanda Allen with Bay Area Legal Services to talk a little bit about NACA and how to get involved with legal aid. Amanda, the floor is yours.
Thanks, Jorge. So thanks everyone for coming. This webinar is a great example of exactly what I love about NACA, also known as the National Association of Consumer Advocates. What it does is it brings together attorneys from across all sectors, private bar and public interest, from housing issues to auto fraud, to creatively and collaboratively protect the consumer rights of our clients and of consumers as a whole. And one of my favorite such crossovers is this sort of collaboration we can have between debt collection and consumer work, along with recognizing that that is a tool to use in these landlord-tenant disputes. If you're not yet a member of NACA, it offers great resources from CLEs to in-person trainings to a national listserv, as well as networking opportunities. Our National Consumer Rights Litigation Conference is happening in Washington, D.C. in November. Discounts are available for legal aid attorneys and nonprofit groups. So feel free to reach out to myself or Max Story for any more information. I am proud that this presentation is going to feature two highly respected attorneys and consumer advocates who also happen to be proud members of NACA and serve alongside me as co-chairs for the Florida NACA. Max Story is the managing partner of his consumer protection firm in Jacksonville Beach. A native Floridian, Max brings over 15 years of experience fighting for consumers. He's nationally recognized in the field, serving in leadership with the Florida Bar's Consumer Protection Law Committee and Florida's co-chair of the National Association of Consumer Advocates. Max is a frequent speaker and educator in the consumer law space with a passion for advocacy and systemic change. Joining him is James Tyer, a dedicated legal advocate with over 5 years of litigation experience. James has worked across multiple states, including Florida and Maryland, in both housing defense and community development. His work with Jacksonville Area Legal Aid and Legal Services of Greater Miami and the Public Justice Center have all focused on empowering tenants and underserved communities. So Max and James, thank you so much for being here. Let's take it away.
Yeah, good afternoon. We find this topic is just especially timely. James joined the practice in January and had a really intense background in landlord-tenant, and as a general consumer practitioner I found almost every other new case that was coming in was tied to landlord-tenant, whether it was a Fair Debt case or a Fair Credit Reporting Act case. It's just one of the emerging fields that's taken over because of a lot of different issues. But you found the same thing, James, I think.
Absolutely.
Let's see. And one of the things we've seen is just as this has taken over, it's always been an unequal platform between landlords and tenants. I mean, from serfs in the Middle Ages to, every time period. But right now it's come to the forefront of again. I mean, it's in the headlines and local news, and Florida's a crisis area. Rents have practically doubled over the last 10 years, but wages haven't. So it's coming to a boiling point. Duval County has been an eviction capital. There's been some good statistics come out that, an average worker in Duval County needs to make nearly $23 an hour to avoid a mediocre 2-bedroom apartment. A third of Jacksonville workers make under that. So there's just, these people are under a rock and a hard place because you need housing, but the money's not there. So it's just coming up with a lot of issues because of this squeeze. The traditional landlord-tenant model usually just had two parties that wasn't equal, but if a tenant went to a landlord, even a money-focused landlord, and they said, lost my job, my wife has cancer, you'd often get some sort of break. But now when you're dealing with calling a Progress Residential, calling an 800 number to Arizona that's outsourced to the Philippines, there's just no hope of any human interaction. Private equity firms I saw have 80% of the apartment complex rental market cornered. So now instead of just a regular abusive relationship between a landlord-tenant, it's more of a throuple. You've got the private equity firm squeezing, the landlord squeezing, and then the tenant there without any protection. Some of the opportunities we found is because the tenants have been, unrepresentative, underserved, and it's a audience that hasn't had, a ton of protection. We find the big companies are making stupid mistakes that normally you wouldn't see in the consumer law arena. Because when we're dealing with suing Citibank or one of these large players, they have policies and procedures and often systems in place to avoid some of the blatant mistakes. So it gives us opportunities at least.
Now, I was able to see while I was working at Jacksonville Area Legal Aid, started there in 2019. It was a little bit before a lot of the big private equity firms had bought everything up. I mean, I think it was still starting, but it wasn't nearly as bad as it is now. And I got to see firsthand, just over time, clients coming in, obviously, having more money issues. Their wages aren't going up. They're not bringing any more money in, but the rent's going up substantially. Not just that, but we began to see a lot of strange charges start to appear on the ledgers and in the leases that just really weren't there before, or at least weren't as widespread. These resident utility package charges, other kinds of cleaning fees, and what it really seemed like these private equity firms have done is they've realized if they increase rent too much, people are going to see that when they're searching for an apartment. They're not going to want to sign that lease. They're find somewhere else that's cheaper. But if they increase it a little bit, but then add the costs on kind of in a hidden way, or a way that the consumer, the tenant, isn't expecting, then they can make up a lot of their money. And I think a lot of companies, I think Max, one of the opposing counsel you spoke with, even said that's where they make all their money, is in all these hidden fees and charges throughout the lease. You're muted, Max.
That's a good point you brought up, James, and it's one of the arguments we've at least been able to present to the conservative judges too, that enforcing some of these protections actually serves the marketplace because when the good landlords and good apartment complexes don't have hidden fees, and you have a family shopping around for an apartment complex, the good players are punished when they're up front, because the family shopping around with the $1,500 budget will move into the $1,500 place, and it turns out that it's not $1,500 by the time they tack on the portal fee, the resident benefit fee, the pet rent. It turns into $2,000. So it's an unfair advantage to the unscrupulous ones, disadvantaging the people who follow the rules. So at least we can try to make some of those economic business arguments to the judges as well.
So we wanted to go through a few examples of some bogus rent charges, just to give you guys an idea of what we've seen anyways. And I'm sure a lot of these look familiar for many of you, but we figured if you can just put in the chat here what you think is maybe the fee that we had a problem with in this, if you can see it well. Actually, I'll go ahead and zoom in here. Our issue was somewhere in this area.
By the way, James and Max, while people look at this, we did have a question come in through the Q&A, and the question was, what do you mean by private equity firm?
So what we're seeing is that the tenants aren't just dealing with the local landlord or property manager. The fees and management is being directed from some out-of-state company that's just focuses on the monetary return. They have no interest in the day-to-day operations. So if they're looking for a 2% increase, in the quarterly profits, they don't care where it comes from. So they're just directing, to the local landlord, add something on. And obviously the rents are fixed for a yearly or 2-year term. So they have to move something around, and that's where we end up with junk fees.
Right, and they'll have, you'll have some Colorado or Texas, you'll have several different entities or people or entities or whatever that want to spend money and invest in property, and they'll pull their money together, and then they'll have that run in some kind of portfolio, and all they're doing, they don't even see what's happening really in that portfolio in terms of like the actual business of managing the properties. They're just saying, okay, we need to increase, profits in this quarter by 3%. Where can we do that? Oh, well, we can add on a couple charges or something like that. So this one's a little tricky. So what had happened to the client in this case is that, so it all started with the non-sufficient fund. It was in her lease, so they were permitted to charge it, but she had actually been charged the NSF fee before she was non-sufficient. So she had actually budgeted all of her money down to where after she paid her rent, she had 94 cents left in her bank account. Somehow, I don't know how, they had tacked on the NSF fee before they had crossed over the 94%. So then that made it insufficient in her account. And I mean, there's a lot of papers that we had to kind of pull through to figure this out. But so that had happened. And so she didn't actually even owe it. But then the other thing they had done here, if you check when she pays for rent, so that would have been October, that was late according to them, even though it wasn't. In November, she paid her rent on October 29th, and yet they charged her a November late fee because the balance was already over because of the prior fee issue. But she had paid November on time. You go down to December, she had paid December on November 27th, and yet they charged her another late fee. So what they were doing, we call this pyramiding. They were charging late fees upon late fees upon late fees. And so at the end, she had a balance of like $1,500, I believe, that somewhere in that range that they claimed that she owed. And it was all stemming from this NSF fee, and then their alleged non-payment of rent for that time, or late payment of rent for that time. And then every time it was late after, because she was able to pay the rent, but she wasn't able to pay the late fee. And here's another one of our cases. This one's very tricky and maybe unfair, but I just want to see if you guys can find anything in here. I'll zoom in a little bit. Here's a portion of the lease, and I'll let this stay for a little bit, and then I'll zoom into the other part. And a few seconds with this.
We have some answers in the chat, by the way. I see renewal fees. We see benefits package charge has been pointed out a few times, and the admin fee.
So the benefits package, I believe that was in her lease, and there are questions about whether or not they're getting their bang for their buck and what they're being charged, but there is a service in theory that they're providing, and it was in her lease. So we didn't have issue with that. Admin fee, we didn't attack the admin fee in this case, but we have had admin fee issues in the past. It's not in this portion of the lease, but she was actually charged additionally a $500 transfer fee, which she transferred from one unit in the complex to another unit. So that we had a problem with that as well. So this one was a trick question. She didn't sign this lease, and all of the charges are based on the new lease that she didn't sign, that they claimed that she signed. Excuse me. It was based on all of her charges should have been based on a prior lease. She had tried to they had tried to get her to sign a new lease. She refused to, and then her lease magically got signed, and all of the charges started adding up. And then a couple months later, she noticed that all these things were being added onto her lease, and she's like, "What the heck is this?" And so she tells them, they're like, "Well, this is based on your new lease." And so she looks, and she didn't sign it. In fact, and we typically hear about these things relatively frequently, not relatively. We would have heard about them before. But what made this case different is the property management company gave her the
audit trail.
Yeah, audit trail. And the audit trail actually had the IP address as for both signers as the property management company's IP address. So we had proof based on what they gave us that it was signed by both parties were signed by the same property manager.
And this was an opportunity that I've heard people say this before, and often I had to take it with a grain of salt because so often our consumers are busy and don't remember some of this stuff, and they click on something, and you go down that hole, and then it turns out they did sign the new lease or what have you. But more and more, all these apartment complexes and bigger property managers use DocuSign. So we learned a little more about IP addresses than we'd ever known. And a lot of people may know this, but an IP address is unique to the location. So the fact that this was shared the same IP address meant that she had to have signed the lease at the same time and place as the leasing agent. And she'd never been in the office before. So it was just an easy matter of technology that they just forged the lease. And I'd ignored some cases like this when people called in, but that was just kind of interesting to look at when your clients complain they never signed the lease. Usually in that DocuSign, they get an audit trail, and if the IP addresses matches up from both parties, it's impossible for them to have signed it separately unless they were right in the same room. So that was just a kind of an interesting one for us to dive into the tech issue.
And here's another one. I'll try to move through these a little bit quicker. Here's another one we found. I think this is the one we just settled. Well, we had issue with specifically a couple of charges in here. If any of you guys have any ideas which ones we tackled in this one, go ahead and put it in the chat. So I believe, Max, we one of the answers is clean flooring, or there's one before the resident benefit fee. I think we did tackle that one in this case, Max, if I'm not mistaken, because she hadn't had it in her lease agreement. So I think it was one of the ones that we included in there.
Yeah, and we're finding some of these cleaning fees, because it's a normal thing you see on the deduction at the end of the lease, but where we're finding traction is the mandatory cleaning fee that's deducted from a deposit. So whether or not they cleaned and left it sparkling, they're being assessed a $200, $300 cleaning fee, whether or not they cleaned it all. So that's easy enough for us to approach as a junk fee. Of course, the better client to have is the person who actually took videos and did leave it clean, rather than the client who left it a mess and the fees actually warranted. But some of this stuff, it's great when it's applied across the board, because it's, open for class treatment, and it bears no connection to the actual damages the landlord suffered for doing the turnover of the property. So any of those things that are just put on every single deduction, and we have the clients complain about stuff that often may be individually unfair but hard to get in and litigate, about the level of cleaning that's just too factually specific, or what level it was left at. But the great stuff is just these automatic fees that are applied in every case, because that's just not fair.
And what was great about this client for this issue was that she had actually hired professional cleaners to clean her unit and had receipts. And so that made it a lot easier to convince the other side, like, look, guys, this is completely fabricated. The unit was spick and span. She'd gotten professionals to do it. Whereas, like Max is saying, when it's like, well, I cleaned it and I took pictures, it's much more difficult. It's certainly possible, but it's much more difficult to litigate that case as opposed to one where, I mean, she hired cleaners. I mean, she's got a receipt and all the proof she needs. I see a couple others in here. The eviction charges. So we are tackling this in a lot of cases. We didn't hear, and we'll discuss some of that a little further on in the presentation. But eviction charges is something we are tackling. Water charges, I don't think we had any issues specifically here, or just any that we saw. And then pest control. So pest control, what a lot of places are doing for pest control is they used to, you would just maintain the outside of the building with the rent. I mean, those are the charges that's what constitutes your rent payment, is maintaining the common areas and paying employees to service the property and those kinds of things. But we're seeing them break out a lot of those charges. And one of the charges we're seeing is common area pest control. So it's not even pest control for their unit, it's pest control for outside of the unit. And it is a service, they are providing it. The argument that we haven't tackled it, but the argument would be it should be one of those charges that's put into the rent, or should be included in the rent, and separating it would be either probably an unfair or deceptive practice. I think that's an idea we toss around. We haven't tried any of those cases yet.
And I think in this case, it's why we find it just important to go line by line through these move out statements, because in the beginning it just seemed pretty innocuous, but we found enough blatant errors in talking to the client going through these fees. This lady complained about pest, and they told her, oh, we don't actually have pest control. We're going to get that instituted next year. So obviously stuff like that is blatant. They'd admitted there was no pest control, but every month she's charged for it. So of course, what I do like about our landlord-tenant practice is often we're not having to reach for some novel concept. We just see something like pest control that didn't exist. And that's just great to go in a case with an automatic, winner. We're not arguing about the quality of the pest control, that they didn't come out half the time. They didn't even have it. And that's what we're finding is good in these cases. It makes them, clean, easy to get the client taken care of, and easy to get paid.
And then I'll just cover this one real quick, just so we can move along. But in this case, the client had moved out of the property. They had filed an eviction. She moved out during the eviction, so they ended up dismissing the eviction. There was no judgment against her or anything like that. In the eviction, they had said exactly how much rent she owed. For previous rents charged, this is actually more than what they had put in the eviction. So somehow this amount was made up, or what I think they likely did was add on eviction fees and some other random fees and just call it previous rents. The concessions payback, we thought this was lawful, but she had a provision in her lease that said if you're found in violation of your lease, or if you violate your lease or in default of lease in any way, then the first month's rent concession that we're giving you, you have to pay back. So we found that to be lawful. Remaining rents, this is what they did, is they accelerated the rent. So she had lived there maybe, I think, 3 months or something like that, and they charged her for the remaining 9 months, even though we found proof that they had moved somebody back in like 2 months after she vacated the property. This also had the cleaning fee. We're tackling that. The admin fee, we're tackling that because she had also cleaned her unit well. And this was another mandatory fee. And then what was interesting here too was, so that made $24,000. It's already a huge amount of money for what she owed was, around $4,500 in actual rent. But then they added this balance here that says if it goes to collections, you're liable for an additional collection fee, which I believe was like 40% or something like that. And that was in the lease.
Yeah, but this was just compounding, because obviously the landlord-tenant statute provides for the remedies when the tenant terminates early or moves out. There's either the 2-month penalty, or they have to mitigate their damages and lease it again as soon as they can. Here they leased it again and just charged her for the remaining 6 or 8 months of the lease term. But on top of that, turned it over to collections, and they tacked on a 40% fee. So that's just outrageous, and that's where we bring up or arguing about penalty, unlawful liquidated damages fees, because that's 40% is nowhere near the cost of sending out some collection letters. So for Brandon, your question, did the lease have an early termination clause in it? It did not. So they did have the right to, they were responsible for reletting the property and mitigating the damage by reletting the property. And she would have been responsible for all of the rent that would have been due for the amount of time between when she vacated the property and when they relet the property. They couldn't have billed her that until after that had been determined, because they don't know how many months that's going to be until after they relet the property. But if she had gotten a bill 3 months later after they relet it, then she arguably would have owed at least that portion. And then the other question was from Joseph: when assessing fees that are incorporated into the lease, Florida being so deferential to the landlord-tenant contract, is whether or not the amount is explicitly included a factor in the assessment. For example, an admin fee being listed as $25 versus just being charged admin fee. So Max was saying we have some issues with penalty clauses and liquidated damages. We'll get into that a little bit later, because believe it or not listing the amount makes it better, or more lawful anyways. But yeah, I mean, to go back to Joseph's comment, it is an uphill battle even when we have clean legal arguments, because years and years the county court judges have just rubber stamped the landlord's judgments, so they're just on autopilot. So when we come in, it's an uphill battle even when we have a great case, because they're just used to this is how it works. Well, this is what we've always signed off on. So that is just part of our climate we have to deal with.
So some of the more common junk fee claims that we see anyways, or that we've tried, most common are a Peralta violation / breach of contract, which we see is essentially the same thing based on the language of Chapter 83. We see a lot of 8349 security deposit issues where a landlord's just either keeping the deposit or adding junk charges in there. We bring a lot of FCCPA Section 9 violations, which is where the landlord's basically charging the tenant something they don't owe, or giving them statements saying that things are going to happen that are unlawful in order to try to collect money. Some others that do exist, the Fair Debt Collection Practices Act, that's a little tricky because it does not apply to principals. It only applies to debt collectors. So we don't see this that often.
But we will apply that to the landlord attorneys on occasion, because they're collection agents.
Well, we see some FCRA cases arising out of landlord-tenant disputes. We handle a lot of FCRA cases, but usually for other types of consumer issues. But occasionally we will have some. We're working one up right now for somebody who had landlord-tenant debt discharged in bankruptcy, and landlord added it back on to reporting it on her credit report. We've had success with conversion and civil theft claims for security deposit issues. We have a malpractice claim that we're trying right now. I haven't seen anybody do that, but we're trying to do that. And then fraud and the Florida Deceptive and Unfair Trade Practices Act. So the Florida Residential Landlord-Tenant Act strictly governs what is permissible in all rental agreements. And what we see, or what we are having issues with judges, is there's a strong presumption of whatever the contract is prevails, because that's how it works in every other arena that doesn't have a statute that strictly governs a specific type of contract. But Chapter 83 specifically and strictly governs what's allowed to be in a rental agreement. And so Chapter 83 prohibits a lot of different things. It prohibits accelerated rent. It prohibits excessive liquidated damages. It prohibits evictions for non-rent charges. The reason I put a bunch of asterisks is because, unlike some states, there is no specific definition of what rent is. And so it says in Chapter 83 that rent is the regular payment for leasing the property, or whatever the lease agreement says it is. So if a landlord puts rent is attorney's fees, rent is utility fees, rent is whatever, then that's usually been upheld as being lawful rent, which is important in the context of evictions, because you can only be evicted for rent. There's fees not in the leases, that's unlawful, and imposing fees on deposits without specific compliance with Chapter 8349. 8347 is excellent for consumer claims and conveying to judges why the contract doesn't matter, at least if it's something that conflicts with Chapter 83, because 8347 holds void ab initio anything that contradicts Chapter 83.
And this has been key, because for years I would take on a handful of landlord tenant cases. It was sympathetic, and you're jumping in to help some poor family. And I thought I'd read through Chapter 83 fairly thoroughly, and I knew it's not that tenant friendly, and they can get your tenants out pretty efficiently. And we kept dealing with terms of a lease that seemed unfair, but like so many times you're having to tell clients that, well, this might not be fair, but you agreed to it, you signed it. And then finally I read through 8347 in the landlord-tenant statute, and it spells out that a provision in a rental agreement is void and unenforceable if it waives the rights, remedies set forth in 83. And this is just amazingly powerful to that argument that, well, you agreed to it, this is America, you signed off on it. The landlord, the property manager, can't just go through and put whatever they want and then rely on the fact that it's in the lease, because that's just their knee-jerk reaction. And we pointed this out to the landlord attorneys who are there every day, and they're astounded and act like they've never heard of it before. So you can't waive the right of a 3-day notice. You can't, tack on different ways to put people in default. If it precludes the rights that tenants have here, it doesn't matter. And I mean, this is just a plain reading of the statute, so this has been key. But it's even been surprising having to point out, this statutory provision that's been around forever to judges, and they've been unaware of it. So this changed a lot of our approach to this case. Is 8347, and it's interesting when you just parse some of the language. It doesn't just prohibit anything that waives your right under landlord-tenant. It also deems anything in the lease void if it limits or precludes the liability of the landlord to the arising under law, not just landlord-tenant law. So we've seen clauses in there that says you're going to be in default if you file bankruptcy. Well, that's something, in the bankruptcy code, you can't be discriminated against for filing bankruptcy. So that clause would be deemed void. So as you go through and look at that, that's been the basis of a lot of our arguments. When we filed class actions under the FCCPA, landlords often have a provision in the lease that they have a class waiver. Well, our response is that a class, you're entitled to it under the FCCPA, which is arising under law. We're having varying degrees of success, but that's the best, argument we've found so far, is going just back to exact statutory interpretation.
Just to address a few of the questions, FC, how do you feel about using FCCPA instead of FDCPA? In most cases, landlord-tenant cases, the FDCPA wouldn't apply because it doesn't apply to original creditors, which means it wouldn't typically apply to the landlord. So it's like Max kind of mentioned earlier, occasionally there'll be, we'll have an FDCPA case against a landlord attorney where it's particularly egregious, the cases that they were bringing. And that wouldn't be covered by litigation privilege either, which is another one of the advantages of the FDCPA as opposed to the FCCPA, where litigation privilege would apply in bringing the suit. Daniel, I see your question that had a case where instead of taking a security deposit, the landlord had tenant pay for an insurance policy. That's a new hot topic because that's in the statute that's now permitted, and at least how the statute says it's permitted. We haven't touched any of those cases. I'm not a huge fan of the statute, but nonetheless, it's there, and we haven't seen hardly any litigation on this issue because the statute, it's really convoluted, and how it actually practically is going to work is unclear, at least from what we've seen. And yeah, noting Kevin's comment, the 8355 definition of damages likely, I think he excludes actual damages, so probably wouldn't have emotional distress and pain and suffering. That's why we like to include FCCPA claims instead of claims under Chapter 83, or not just claims under Chapter 83, because the FCCPA does permit emotional distress and other those kinds of actual damages. Yeah, security deposit violations, there's a lot of good litigation for this issue because, like we said, Chapter 83 requires strict compliance. There's good case law. This case that we cited is the one that we reference all the time, where if a landlord doesn't strictly comply with the requirements of Chapter 83 or 8349 specifically, then they have no right to impose a claim on security deposit. The important thing that we point out to the judges is that it's not the landlord's money. It's the tenant's money. The landlord gets to hold it in trust for a period of time until such time that they fully comply with requirements of Chapter 8341. If they don't do that, it stays the tenant's money.
Yeah, and one of the arguments we've made, remember, trying to fight this uphill battle in the county court system, is that this is obviously the tenant's money. And I mentioned this is just like lawyers' IOLTA accounts. We're strictly held. We can't tack on a admin fee every month and deduct that out of a tenant's trust money, because we build that into, part of our agreement with the tenant. It's their money, and at least judges and attorneys know that that's strict immediate punishment messing around with IOLTA to funds, because it's just been kind of a matter of course that the landlord is going to keep your deposit. So trying to push on that they have a fiduciary duty to hold that money for the benefit of the tenant, and it's the tenant's money, not just their money to grab with whatever fees they put in.
We think because of that language, we've had success on at least one case with conversion and civil theft. There's a few others in Florida Law Weekly as well, but people haven't really been doing this, and I think it's ripe for these kinds of cases. The way that we would try to work them up is, the tenant either gets no letter or gets a defective letter. We'll send one initial demand letter saying, look, you didn't comply with 83, give the money back. They'll ignore that, and then the civil theft statute requires a specific statutory notice. We'll send that letter. They'll inevitably ignore that, and then as long as you've worked it up right, it could be a good civil theft claim, since, like this is all pointing out, that money is the tenant's money. And so if the landlord, without lawful right, takes that money and puts it to some other use without complying with the statute, then they've stolen the tenant's money by statutory definition.
And another thing is just those are easy claims, because we have areas where it's nice to expand the law, but that demands strict compliance. That if your tenant doesn't get that notice about the deposit, that's an easy case to bring, get the money back and get fees.
And Joseph, I see your comment. So this is the common one of the common problems that people have with using civil theft. In our research, and what we were able to convince the court of in the case that we had success with, was criminal intent. If you're committing a crime, okay, say you're committing battery, you don't have to have an intent to batter. You have to have an intent to do the thing that caused the batter. So the act itself, did you intend to do the act, or was the act accidental? So the mens rea, I guess, for the criminal intent element is, did the landlord mean to convert the money, or did they not mean to convert the money? Like, for example, where it wouldn't be met would be if the landlord sent the money, but they sent it to the wrong tenant because there was some mix up in their files, or they inadvertently, there was a glitch in the system and they didn't send the notice out or something like that. They wouldn't have the criminal intent requirement because they didn't intend to do the act. They didn't intend to do the deprivation of property or convert it to another use. But if the landlord did purposefully move the money over here, or did purposefully hold on to the money or deposit it somewhere else or whatever, then they've intentionally done the act. That's all you need for the criminal intent element. It doesn't matter whether or not they knew they were stealing. You don't have to know you're committing a crime for you to be committing an intentional crime. It's the intending to do the thing that was a crime, because that's the ignorance of the law is no excuse line of thinking. Yeah, some other just common junk fees that we see in security deposits. We see mandatory cleaning fees, administrative fees, government COVID fees. That was popular during COVID. Late fees that don't match what's in the lease, pyramiding of late fees, penalty fees that don't match any actual costs to the landlord. So the late fees not matching in the lease, a lot of times what's happening is a big property management company takes over. As we mentioned, these are all run top down. So some big company has a formula of what late fees are. And regardless of whatever all the leases say that they might have taken on from a prior owner or prior lessor of the property, they'll just start charging this amount because this is what we charge for late fees. Well, if you're doing that and the lease says something else, then that's unlawful.
And that's stuff that's just nice and clean. So when we get these cases in and looking at those deductions, we get out a copy of the lease and just go through and highlight and see what matches up. And because the tenants have typically been underserved and there's not been a ton of litigation, often they just don't care. The new people may have signed the lease that has $100 late fee, but your person still has $50 and they just assess the 100. So that stuff is just nice and clean. But we found applying the Florida Consumer Collection Practices Act, almost every single landlord-tenant claim has been huge, and you're doing a disservice to your client if you're not including the FCCPA count on a landlord tenant claim, because they line up perfectly, because the basics of the FCCPA is the protections to the consumers or debtors from a creditor. And the whole basis of the landlord-tenant relationship is a debtor-creditor relationship. They're paying rent, and they're everything to do with the landlord's action typically is enforcing rent. And even, the eviction is based on the non-payment of rent, even though they may argue that it's, enforcing a property interest. And there's so many benefits to including the FCCPA claim to any of the, landlord-tenant claims is the Peralta is really weak that you only get actual damages that don't include emotional distress claims. We've tried to put them in, and I saw a comment from Kevin, well put, that they should include emotional distress for actual damages because so many other statutes do. And when you look at, what's at stake here, if you have a family that's going to be out on the streets due to predatory practices, there is a ton of uncertainty worried about your family being on the street, but we don't have any case law that says you get emotional distress. So FCCPA gives you emotional distress, and this is stuff that's not a stretch for a jury or judge to understand. Pushing you out from the roof over your head, that's real. That's not just a frivolous argument. And we get statutory damages under the FCCPA, because if there was no harm done, in a landlord-tenant action, it's still a violation if they're charging an amount that's not due. So at least the tenant's going to get the statutory damages. And the fee shifting is huge too. Under that CCPA, you're going to get paid on a violation. It's nearly strict liability. The only way it backfires is if you're filing a frivolous lawsuit, which we're not going to do. So if you lose under the FCCPA, no problem. If you lose under Peralta, you have a client who's usually not wealthy, could get hit with these fees. And then as we look later on, the fee shifting is really weak under the Landlord-Tenant Act. Of course, it's never weak when it's applied to our tenants, but when we come forward and sue, then they look at we may get fees. Of course, every eviction, when they want to tack on fees to the landlord, that's rubber stamped. But on our side, when we're bringing a landlord-tenant violation, there is focus on the may get fees. So yeah, James, you put a lot of focus on this.
Sure. Just another couple of questions. The pyramiding of late fees. We have an example later that we'll actually go over in a little bit of detail. And Joseph, if you want any more information about the civil theft conversion for the security deposit, this is a case that Adam Thorson from Jacksonville Legal Aid and I worked on when I was working at Jala. This case is published. It's Charles Bond versus SOAR Emerging Markets. And that's in Florida Law Weekly, and it goes through an analysis of all of this stuff. We also have a good motion for summary disposition that wasn't published, but you can find that in the county court filing, and that goes through some of the analysis as well. So attorney's fees under Chapter 83 in the FCCPA are hotly litigated, and there's a lot of nuance that is really, really critical. So under Chapter 8348, which is the general fee provision for Chapter 83, any party in whose favor a judgment or decree has been rendered may recover attorney's fees and court costs from the non-prevailing party. If there's no judgment or decree, you're not entitled to attorney's fees under Chapter 83. We're litigating these kinds of cases now, where landlords are charging attorney's fees sometimes before filing. So there's no eviction even filed, and they're charging attorney's fees, or where they file, where they dismiss, and there's no judgment or decree. So we're using this strict language to say that the landlord doesn't have any right to charge the attorney's fees unless a judge has determined them the prevailing party in litigation. They have a judgment against the tenant. Of course, that very rarely happens. Usually a tenant will move out, they'll dismiss, something like that. So we're focusing in on that specific language. Chapter 8349, however, the specific security deposit provision of Chapter 83 says if anyone institutes an action, the prevailing party is entitled to receive court costs and attorney's fees. Well, so that doesn't require a judgment. So just whoever prevails. So if you were to file a case and somehow we filed a bad 8349 case and then we dismissed it, the landlord could then move for fees against us without having a judgment or decree. So that's significant. Chapter 8367, however, which is another subsection, this is the subsection that deals with unlawful lockouts or self-help evictions. Any landlord who is found to have violated any provision shall be liable. So there's no discretion for the judge to award fees if the landlord's found liable. So all these nuances are important. Part of why we focus on the FCCPA for a lot of our landlord-tenant disputes is, as Max was explaining, it's broader. The fee entitlement applies to any person who fails to comply with the statute. So if you get a judgment that says they failed to comply or they violated the FCCPA, one of the provisions, they are liable for court costs and attorney's fees.
Yeah, and just to add another advantage to always adding on the FCCPA claim, because it matches up so perfectly, is it's a lot more pro-consumer. Any communication from the landlord that's threatening and the emails back and forth to the property from the property management company, those communications are viewed from the perspective of the least sophisticated consumer. Totally different than the reasonable consumer. So if it looks like they're telling you you're going to have to get out tomorrow because they're saying we're going to file the eviction and you better leave, that's not accurate. Obviously they have to go through the court process, but that would be a clean FCCPA action because the least sophisticated consumer is basically being told get out or the sheriff's coming. So any of that stuff is just cleaner to bring and prevail under the FCCPA using Chapter 83 as some of the basis for it.
I'll go through the next couple a little bit quicker so we can get through to some of the examples and hypos. So liquidated damages are permissible in contracts, period, in the state of Florida. Lease agreements or contracts. Penalty fees are impermissible in any contract in Florida, and really we found good case law nationwide. It's a generally held principle that penalty fees are void and unenforceable in any contract. And again, that includes lease agreements. So this is good language that we can use because we have to usually be fighting against judges' preconceived notions that a contract is is sacred and whatever you put in it is what controls, and you have the right to freely contract for whatever you want. because Chapter 83 says otherwise. But this is an example we actually get to use general contract law in our favor to say the landlord's including all this stuff in there. If it's a penalty fee, it's not okay. If it's liquidated damage, that's okay. So what's the difference between liquidated damage and penalty? A liquidated damage charge is any charge that compensates a landlord for actual harm, actual damage that they've suffered, actual costs they have to pay. A penalty fee is not. A penalty fee is not directly tied to the actual harm, is not directly tied to any cost. It's intended to induce performance. And I think we know in most lease agreements, eviction charges, late fees, all of these different things, they're really just penalties against the tenants, trying to make them pay on time or make them pay the rent so they don't get eviction against them. They're not actually compensating the landlord for any money they've had to spend. So for something to be enforceable liquidated damage charge, it has to be not easily ascertainable. So eviction charges are great, and we're working on litigation with that because typically all those charges are itemized. You know what you pay for a writ of possession, you know what you pay for filing costs. Use the same, with the big property managers, use the same attorneys that bill the same hourly rate for whatever, usually a flat rate for whatever evictions they're filing. The second requirement is that the sum has to be proportional to actual damages. If it doesn't satisfy those two criteria, it's a penalty fee and it's unlawful.
And that has been a lot more powerful an argument in conservative courts than I think what often our consumer attorneys initially default to, that judge, this isn't fair. And they're like, it's in the contract. I don't care about your fairness or your feelings. And then we go to, well, it's unconscionable because that's, found throughout, landlord-tenant and our statutes, but unconscionable is, such a variable term, and find it grossly unreasonable or shocking the conference to a judge who deals with this stuff is really going to be an uphill battle. And looking at, the limited case law we found on unconscionable fees, they had to be so, blatant. A late fee that was, $400 was found unconscionable. But looking at this unlawful liquidated damages is more of a business, accepted corporate term that, a $200 late fee might not be shocking to the conscience, but it doesn't match up with the actual in-house of the people, the property management company sending out a letter and the interest they might lose by a payment that's 5 days late. So it's just a cleaner way we're finding to go after these fees because they don't reflect what it actually cost.
They wanted us to go over Section 8 rentals and how what landlords charge in Section 8 rental agreements might violate some consumer statutes. And this is, I'm sure many legal aid practitioners are very closely acquainted with Section 8 voucher agreements and how the laws work. And it's very complicated and complex. And we're only going to skim over the surface of some of this. But basically, Section 8 rental units are rental units that are governed by a three-way relationship. So it's a tenant who will go to a housing authority and they will apply for a voucher. The voucher will be approved by the housing authority and issued, and that's being funded through the federal government that gives the housing authority that money. And then using that voucher, the tenant will then go and rent a private rental unit. Well, that contractual relationship is heavily regulated, and there are frequent missteps that landlords do, that they charge things they're not supposed to charge. What's important is landlords will sign a HAP contract with the local housing authority, which will include a landlord certification of responsibility that says that they know and understand exactly what they're required to do in a HAP contract, which will include what they're allowed to charge. The tenancy addendum will issue, and it is a part of the lease agreement by law. So as a matter of law, it says anytime you're entering into agreement for a voucher, that's part of the lease, whether or not you physically include it. And so what if the lease says something else other than what Section 8 allows? Well, under Section 8 voucher leases, a landlord may not charge anything that's not approved by the housing authority, and any rent in excess of the housing authority determination portion. Rent is determined in an interactive process which considers all housing and maintenance services. And so the housing authority, in theory, and again, I remember having plenty of issues with our local housing authority when I was legal aid, where they wouldn't necessarily go through and add up all these charges and make things very complicated and a big pain to deal with. What they're supposed to do is go through, figure out all of the charges that the tenant's going to be responsible for, and all of those charges are going to add up, and the housing authority is going to determine, okay, then your rent's going to be approved. And they have certain limits they have to meet. And if the housing authority determines, well, you can pay $1,000 a month for rent, we'll cover $800, you pay $200, for example. The landlord has to either agree to the $1,000 or that's it. They can't sign the lease, and the tenant moves on to another place. So in the tenancy addendum specifically says the landlord can't charge the tenant for any of the portion that the housing authority is supposed to cover. This will sometimes happen when the tenant will be considered late, when a housing authority sends a late payment, and they'll be charged for that. That'd be unlawful. They can't charge, landlord can't charge or accept payment for rent of the unit in addition to the rent to owner. Again, these are very specific terms of art under the federal regulations. Rent specifically does not include meals for supportive services, items customarily included in rent at no additional cost to unsubsidized tenants. And you also can't add or increase charges without housing authority approval. So one of the things that I saw that I dealt with was a tenant was being charged for a refrigerator and washer dryer. I think a stove or something crazy like that. That sounds bad in and of itself, but what made it clean was that we found other leases where the landlord wasn't charging those things to any of the other renters. And so it's pretty clear. I mean, intuitively, you'll know that that's a side payment and an unlawful charge, but it helped to find other examples where that's clearly what they're doing. So there's a lot of good case law on side payments. And I'll throw a plug in here for the NCLC's Green Book, Digital Green Book. There's a whole section on side payments and key TAM cases. So if you're interested, take a look there, because there's a lot of good case citations and explanation about side payments. But just for our purposes, a side payment is any impermissible charge, which includes when there's a difference in the proposed rent and the contract rent. So for example, the landlord will agree to the $1,000, but then they'll issue a lease with $1,100, or they'll issue a lease that has an addendum for an extra $100. Utilities that aren't specifically approved by the housing authority. There's been really good case law for that as being a side payment. Landscaping services have been found to be side payments. A storage shed has been found to be a side payment. Washer and dryer, that got a little tricky. I've dealt with plenty of these issues, and shout out to Mary DeVries at Jacksonville Area Legal Aid. We went back and forth about a lot of these, finding kind of the gray area where is something a side payment because it's rent being charged, or is it an extra service that's okay to charge separately. Washer and dryer was one of those ones where it's like, well, you can rent a washer and dryer from Aaron's or some kind of like rental place, and like if you're just doing that from the landlord instead of doing it for, maybe that's okay, maybe that's not technically rent, but you could rent the property without it. So is it additional service, or is it rent services that should be included? There's a lot of gray area for a lot of different issues like that when it comes to side payments. A lot of these cases will be good FCCPA cases because since they're so heavily regulated by federal law, usually you'll be able to determine pretty easily whether or not something is just unlawful and it shouldn't be there. And if they're charging it when it shouldn't be there, and they shouldn't be, it shouldn't be in the lease or it shouldn't be on the ledger because of what the federal regulations and the HAP contract say, then that's an FCCPA violation. And what's important to point out here, and a lot of these cases show, when the landlord's accepting rent in excess of what the housing authorities approved, they're in effect committing fraud against HUD. So the government takes it very seriously. I think many landlords don't understand that that's what they're doing, but the key 10 cases show that once if they'll take up these cases, the DOJ will actually take up these cases. they prosecute them very seriously. So we have a few case examples that we wanted you guys to look through to see if you can issue spot what we had happen here in these different cases. And then we'll kind of explain what we did with the case and how it kind of turned out, or if we're still litigating the case, kind of what angle we're taking on it. So this is one, this is an example. This guy named Carl used his voucher to rent a room in a single family home, which was split into several different rooms. And a charity helped him obtain his security deposit and paid it on his behalf. Since there is only one electric meter for all the units, the landlord had him agree to pay a flat $50 for utilities per month in addition to his rent portion and the housing authority's portion. A few new families move into the unit. The electric bill skyrockets. Landlord wants to increase his rent or his utility payment. He refused. The landlord then shut off the utilities for the entire building and called the housing authority to tell them he wasn't making his payments, and so they shut off the utilities. The housing authority told the landlord, which one of the rare circumstances where our housing authority was doing the right thing. They told him that's unlawful. You got to reconnect the utilities. But then they issued a voucher terminating for the non-payment. So they did one thing good, they did another thing not so good. He won the hearing, showing that he had paid what he actually owed. Landlord then shut off the utilities again. About 3 weeks later, his lease expired. We vacated the unit. After 30 days had passed, he emailed his landlord asking for the return of his deposit. A few days later, they emailed him a list of charges he owed, including utility charge, storage units charges, and other damages charges, which were all made up. Said they were keeping his deposit and that he owed that balance, an additional balance. He mailed a letter to his landlord explaining that he was entitled to his deposit return, and they ignored the letter. Do you guys have any ideas of how we attack this case? And I'm putting in the chat, but the Charles Bond case was against store merging markets. So this case, just so we can move along a little bit, we did a few different things. We ended with summary disposition against the landlord for liquidated damages of $8,000. That was our small claim. We filed in small claims court that we maxed out the cap. We got $160,000 in attorney's fees. This case was a great case, but also a mess. We prevailed. We had a Chapter 83 49 claim for failure to return deposit. We prevailed on conversion. We prevailed on civil theft. Then we had an FCCPA claim for the lockout and the lockout claim for the lockout. And there was 2 lockouts. And we prevailed on arguing for both of the lockouts. The issue with this case, we prevailed, but it was a relatively mom and pop landlord. They lost. And they filed an appeal. We prevailed in the first appeal, or they really just stopped litigating it, in the appellate court dismissed it. And then they filed another appeal for the fee judgment with no clear basis. And then they filed bankruptcy. And at this point, we've been dealing with, or Jacksonville Area Legal Aid, this is when I was working for them, they've been dealing with the bankruptcy issue now for about 2.5 years. So we haven't gotten a penny for any of this. So I think we oftentimes, we won't often go after some of the mom and pop landlords because of situations like this. I mean, it was a great case and a great order, and hopefully, this is something that people can use for bringing these kinds of cases. But we haven't gotten a penny because the landlord was small time, and we got a lien on property, but then she owed other property, and it's a mess. So this is another one. Lizzie. So Lizzie rented an apartment with her 9-year-old daughter. Her lease included a $200 late fee payment, a $35 for rejected payments. Throughout her lease, it only allowed mailing payments, but the office always accepted walk-in payments. They sent her an email saying they weren't going to do that anymore. They only gave her a couple options. They, really didn't explain the options other than doing through their portal. So when her lease ended, after her lease ended, she and her landlord agreed to change to a different unit. They charged her a $500 on-site transfer fee that she wasn't expecting. They also started charging $1.10 insurance waiver fee that wasn't in the lease. So in October, things got tight for Lizzie. She saved enough money. I explained a little bit about this case earlier. 96 in her account after her rent payment, which she made through the portal. However, her landlord charged an additional $25 fee, apparently an NSF fee. I think it was 35 actually, which bumped the account over. It was not over before the NSF fee was applied, but only after. Due to the non-payment, they charged her a late fee and she was served a 3-day notice. The notice was later addressed to both her and her daughter. So her daughter was listed in the termination notice. She was able to get October pay, but still wasn't able to pay for the late fees. And because of the failure to pay the late fees, she had an account balance carried over for November, December, and January. And even though she paid all of those months early, they charged her for the balance of late fees. They ended up leaving around $1,000 or $1,500 or something like that at the end of January. So I'll just move through this one. So this case, this was the pyramiding case. We settled this one for $15,000 pre-discovery. So basically, we attacked this as unlawful pyramiding. So we attacked the NSF fee as an improper charge because they shouldn't have charged it at the time they charged it. And if they hadn't charged it, she wouldn't have gone over. So they basically created the situation where she was responsible for the fee. But then on top of that, we argued it was unlawful for her to charge a fee on a fee on a fee. And that's what we call pyramiding. And there's good case law for this as well. And I believe this is one of the complaints that we included in the materials. But pyramiding is when somebody is charged a late fee because they pay late 1 month. They pay all the rest of the months, fine. But because that one fee is what's creating a balance in the account, the way they have it set up, it's just issuing the fees if there's a balance, then they're being charged a fee on top of that. And then the next month, a fee on top of that. And then that's the pyramiding, is it's just stacking fees on fees.
And this is one of those claims that makes sense, and it's intrinsically unfair when you explain that the person was late once, and over the last 12 months they paid their rent on time. But there was limited case law, and we found some examples, and it's, I think, as an accounting principle, it's not allowed. But also some of these factors are, once we filed this, something we dug into, we were pissed off. This was a nice single mom had been bullied by these people, and we put together a 35-page complaint with 8 counts. But then we got assigned to the most conservative judge in Duval County. So we also kind of got lucky on negotiating this out and getting out before we actually had any hearings, because also when you're pushing reasonable theories without a whole lot of case law, you hate to just get motion dismissed and have the whole thing down. So we kind of had to look at the practicality, and we kind of got lucky. Decent opposing counsel saw it'd be a mess. I mean, a lot of work to go through this, and we got out for 15 grand before discovery, which wasn't some huge payday, but great for the client, paid our fees, but also just kind of judging the reality of where we'd end up with the conservative NRA judge.
And I'm just gonna kind of click through the rest because I think we're getting low on time, and I'll just give you the brief overview of what we did with it. This is the one that I mentioned earlier, and all this material is in the PowerPoint that we're going to have uploaded. So if you want to take a look at any of these, and of course, if you have any questions about them later on, feel free to shoot us an email. We're happy to talk about these cases. This client we had, this is the one where she never signed the lease. They were reaching out to her over and over about renewing her lease. She didn't want to. She didn't want to pay the increases. This was one of our big local companies that took over a prior lease, and then they're like, no, we want to add all these crazy charges. That's what we do. That's our business model. She didn't want to do it, so she just ignored them. And we still don't know what happened exactly. We just know that she didn't sign it, and somehow they or their system signed it. It was a very interesting case to litigate because the way that we entered the case was we entered in to defend the eviction. We filed a motion to strike. We filed an offensive case at the same time. The case ended up being a mess, and we were dealing with a local landlord attorney who didn't know what the heck was going on. So we had a hearing on the motion to strike. We did request for judicial notice as part of how we found about the IP address was we found other leases that attached the audit trail in cases they had filed, and they were all different in those leases. But in our lease, it was the same. We got an IP expert guy who wrote a report. We explained like this is how IPs work. And we actually litigated this case significantly more than we should have, given the facts that we had, because it was pretty undisputable that she never signed the lease. And so we litigated this court for like about 4 months until they realized they didn't know what they were doing, got another attorney to take over the case, seemed to realize how bad it was, and we ended up settling this case quickly for just under the jurisdictional limit of county court.
But also, this is one of the cases we thought was outrageous. Here we proved they forged a lease, and we have an evidentiary hearing with the judge. And even as old as I get, I was still naive, expecting the judge to be outraged when we showed a lease had been forged, and just a blank look and a shrug. So it was just one of those moments where you realize, we're pushing an uphill battle when we have proof a lease is forged, and the judge just kind of says, oh, well.
Yeah, and what was interesting is that's what made it so expensive, because we thought we had enough to work with where we just get this case dismissed because we had the audit trail. Surely that, plus her history of saying I'm not signing a new lease, plus her initial dispute, because right after she figured out that the lease had been signed, she disputed, saying I never signed this. I've never seen this before. What the heck? What is this? We thought that would be enough, and since it wasn't, we had to go get an IP expert. We had to do all this research for the cases. We did extensive discovery, requests for admission, interrogatories, did a couple of depositions. We had to do all of this before they even realized what the heck was going on. And that's what made the case so expensive when, we thought we had enough to begin with. But, let's see. This is the class case, Max, if you want to talk about that one.
Yeah. So I think this case is a great example showing some of the easy violations out there, and an example of why classes are good for some of these cases, because if a property manager, they're not doing this stuff one-off to your client. We're working with a uniform lease, often they've used forever, and they're using the same move-out statement. So yeah, actually, let's move on to the next page here. Let's enlarge this.
Yeah.
So this is the typical SOTA or statement of deposit when everyone moves out, and the typical stuff is in here, which the clients are often mad about housekeeping, but it's such a fact issue. Light bulbs, I'm sure, some of this stuff is excessive, but again, that's factually tough to find. But what stood out here was admin redecorating fee, $250. So at first, when that looks suspicious there, $250 for an admin fee, that's not any damage to the property. And then, do we have that language on the next? No, actually, the lease, one of the weaknesses initially in the case was the lease allowed for this. So of course the defense counsel says, look, they agreed to it. You may be liable for an administrative fee of $250 if repairs in excess of $500 are required upon vacating. So if you have $500 of damages, they tack on $250, and their attitude was like, well, that's reasonable. Look, we have to do this work. It's more work for us. But our position was, you're a property manager, your whole job is to turn over properties. And the part of the security deposit is for damages. You've already incorporated in, your labor is here. You don't charge for a light bulb, you also charge 20 bucks to install it. And as we went through discovery too, of course, the property manager charges an additional fee to the landlord for turnovers. So they're being paid twice. And what we see with the property managers is often the fees they tack on the clients don't go back to the property owners. So this is all gravy, late fees, admin fees they get to put in their pocket. So this ended up as a settlement class, but we got through the insurance defense counsel that this was a valid enough fee that just tacking 250 bucks, out of the tenant's money is violative of the FCCPA and Feralta. So not a huge class, but we got about 120,000 going back to the class members who paid it. For the people who were threatened with it but didn't actually pay, that was an FCCPA violation, and about 200,000 in debt waiver. And debt waiver is something easy often to get out of the landlords and property managers because it's not costing them anything. And usually they're never going to see it. But for our tenants, having that landlord debt pop up when they're applying to an apartment complex is a real black mark against them for getting new housing. So it's something we always look at because it's easy to add on to a class settlement for them to get debt waiver. But we got 10,000 to the client, we got 80,000 fees, and then for the funds that aren't collected by the tenants when the checks are sent out, we probably have about 35,000 going to legal aid. So class actions in these arenas aren't like these shock and awe $1 million class actions we read about, but still a decent result and actually affect some change because the tenants who were under this lease, it was stricken, so they aren't going to be hit with this penalty, and then they're not going to use it going forward. But the great thing is it's something pretty simple. That one line in that statement of deposit, is the basis for a decent class action.
Yeah, we only have 7 minutes left, so I'm just going to kind of scan through these. We had a couple other good ones. Happy to talk more about those if you look over the materials and some of those stick out as interesting. We're more than happy to talk about any of those. Just one more plug for joining NACA. A lot of this stuff that we've learned and a lot of these different kind of cases have come through networking with other attorneys around the state, nationwide, and seeing some of the other work that they're doing, some of the cases that they're tackling on, and of course dealing with other professionals outside of our area of expertise and being able to see, okay, this, we can use some of the principles that they argue in these kinds of cases, apply those over here. That can be very, very helpful and useful. Go ahead and read a couple of the questions that we have, and if anybody else has any questions, we're happy to address those. Joseph asked, as a general practice, property managers are frequently including these payments for fees for paying rent, the NSF fees and stuff like that. If it's not expressly in the lease, would it be a violation? Would it be unlawful? So it kind of depends because they have to have some contractual basis to be charging it. They can't just make it up. Sometimes we'll see that in the lease. Sometimes on occasion, you'll see that as when the tenant's going through to set up the portal, they'll agree that the portal will charge them $5 for using or something like that. If they agree to it there, that might also be lawful. But if they're just adding it on and there's no other way or no other option for paying their rent, then that could be a violation. It's very fact specific. And then of course it depends on whether it's a penalty fee, because if they're charging $50 but it costs them $5, well then that's a penalty fee, even though it might be lawful because it's in the lease. It might be unlawful because it's a penalty fee that's in the lease. Let's see. How do you handle cutting off access to portals to prevent payment of their rent? I've never dealt with this. I know this is something that people deal with quite a bit. I think it's tricky because I think if a landlord gives a tenant a non-payment notice, and what I would usually see this is like after the non-payment notices are given, this is what the landlord would do in order to stop access to the portal. I think it's tricky because if you give the non-pay notice, the tenant has 3 days to make payment. If they don't make the payment within the statutory period of time, then the landlord has no obligation to accept their rent. They can file an eviction immediately after that. On a lot of the portal systems, there's no way to stop the tenant from paying unless they shut off the portal. And so I think there would be some argument the landlord can make of like, well, this is the only way that we can assert our right to move forward with the eviction, because if we don't shut it off, they may pay, and then we've filed this case for nothing. We can't evict them. So I think that's something that I'd be worried about for that. If I would argue if they terminate it before the statutory period expires, where the tenant's allowed to pay rent, then I think that's an argument that the violation's bad, or the eviction would be a bad eviction, and they wouldn't be able to move forward. But I think I would maybe say that that's it could be a lockout.
Oh, and then just as a practice note, too, with these payment portals, it's key if your clients go through and screenshot or print out these payment portals, because once an eviction's gone through, they're locked out, and that's our evidence to show some of these bogus admin fees that get tacked on. And then we also try to use our clients as investigators and call up or email the property manager and just neutrally ask about, I don't understand this fee. What's the basis of it? And it's interesting to see what responses you get back.
And then I think Joseph and Chandra, looks like a portal shut off, arguing that it's a 8367 violation. I haven't seen a case in my research where that's worked effectively. I know that the termination of services language in 8367 is broad, and it's been applied broadly. So I think there's definitely room to make that argument. I just think I would want to be very careful about the facts, and like anything, good facts make good law. Because since it's a gray area, I'd want a situation where the equity would be in the tenant's favor, not a case that's kind of on the line. And as we know, unfortunately, judges are inherently suspicious of tenants, and especially when it's a situation where they're behind on rent. And so I'd want a situation where, in some way the equities are in the tenant's favor.
Oh, and then just one follow-up. We skipped through some of the slides because we're running out on time. But what I wanted to emphasize is the easy cases are great. And sometimes just looking at the math here we saw charges for JSO, Jacksonville Sheriff's Office RIP fee. And I think that they charged the client $250 and labeled it as a JSO RIP fee. But you go on the Jacksonville Sheriff's Office and it's $90. I mean, that's just complete junk fee mislabeling. We had another case where they said the filing fee for the eviction was $500. You go on the Duval County Court site and the eviction is, $127. So just lining up the math is stuff that they can't argue with and the judges can't argue with. We're not making feel-good arguments. We're just, math arguments, even attorney math.
All right, so I did want to announce the CLE code out loud. I dropped it into the chat just in case, and it will go out via email, but the CLE code is 2506812N. I know we were not able to necessarily address all the questions, but feel free to, I included my email in the chat, and you will also have my contact information from Zoom. Feel free to email me any questions that we may have missed, and we'll try to get answers back to you. I know we mentioned NACA. Be on the lookout for those membership benefits, not only for private attorneys but for legal aid organizations. There was one comment in the chat about class actions and restrictions that I wanted to make sure to quickly address. Not all legal aid organizations are LSE funded, so they don't have the same restrictions. We actually have a great webinar on this where Aaron from JALA explained all of this, so I'll make sure to include that in the and the materials because I think it's beneficial for everybody, not only the legal aid attorneys. So I see a lot of thank yous. So I wanted to thank Max and James for joining us. We are planning our next Consumer and Housing Umbrella Group conference for next year. So more details will follow soon. I feel like this was a great teaser, and this just shows how great of a conversation we can have with these topics. So with that said, if you're a PILS member, we'll be joining the meeting and the link that Laura sent. We will be joining that meeting soon, but as everybody keeps dropping their thank yous, thank you again, James and Max. Have a great rest of
Yeah,
your
but
day, and we'll see you at the next one.
yeah, James and I love talking about this stuff in this area of law. So we're happy to discuss issue spotting and going over any cases people have, because the more we kind of share the collective knowledge, the better.
Awesome. Thank you again. Have a great day, everybody.
Thanks, everyone.